we're going to get started. I just have one quick announcement. We've gotten about 4 donations for the elementary school, so if you have Venmo, I'd like you to open your Venmo right now and go to @EliHaddad, ELIHADDAD, and donate $5 to $50 so we can go buy some supplies. We are streaming live now, so you guys are ready to go. I'm going to go ahead and get out of here and get out of here. Okay, thanks guys. Don't forget to donate @EliHaddad. Thank you. Are you going to go on?
It's like I'm out by 8.
All right, we'll introduce ourselves. So I'm Jody with Holbrook and Holbrook. Becca is with me as well. We'll be going through some fiduciary transactions. So that's typically estates, trusts, and POAs. Another example is like signing on behalf of the company as well. So we're going to go through kind of the highlights of what to look for. Obviously, at the end of this, nobody expects you to, there's not going to be a bar exam for the estates or trust portion, but we'll at least let you know what to look for, what questions to ask, so that you're not ending up with a delay at closing, waiting on a probate court somewhere. Any questions before we jump right in? You had something going on, you just want to get off your chest before we start? All right, we'll save them till the end. Yep. Yeah. Yeah, feel free as we go along. Let's hear all the hypotheticals, or I had this one client stories. Those are sometimes the best way to learn. We'll start off with estates. You know, a lot of the property transfers that we run into are deaths and divorces. They cause a lot of sales. So you will run into them from time to time if you haven't already. And there are a lot of different variations of how an estate can turn out. So the first thing is know what to ask your clients. When you realize that the current owner of your property is not your seller, so to speak, you've got a few starting places. So the easy one is if the property was owned by 2 people as joint tenants with the right of survivorship, is typically the setup for a married couple. Then as long as one of them is surviving, they would become the sole owner upon the death of the other one. Nothing is required to go ahead and sell that property. No probate actions, no heirs get involved. It's as if that other owner, the surviving owner, has owned it by themselves forever. So that's what you hope for if you're dealing with a deceased situation. If that's not what you've got, or if both of the owners who had it as joint tenants with the right of survivorship have now passed away, then you're dealing with the last one to pass away, and you're dealing with their estate. First question you'll need to ask your seller or your point of contact is, have you all started a probate? Now that is not always required, but typically it will be. Whether or not there's a will, most situations are going to require that probate, and what that does is it closes off claims to the estate so that someone can't come forward and say, oh, the deceased owed me a bunch of money and now I'm going to take that out of this house. If your deceased has passed away more than 2 years ago, then those claims are kind of dead at that point. That's the statutory time frame. So at that, you probably wouldn't need to open a probate estate if the deceased has passed away for more than 2 years. But that's typically a rare situation. More generally, you see people the heirs are trying to sell the house within several months of someone passing.
Yeah. So on the first one, if a spouse has died, are we supposed to get like a copy of a death certificate, or do you do that?
It's not typically required.
It's not.
No, you just need the date of death to
Okay.
include in the chain of title.
Okay.
Death certificate, some closing attorneys may ask you for that. Typically what we'll do is just do our own research to make sure that that's the case. I've not run across somewhere where a spouse was pretending their spouse is dead yet, but we do an internal check on that, and the Department of Vital Statistics in Frankfurt keeps the track for us.
What if you have a missing spouse, like for years?
Yes.
What's in?
So that has happened before. The scenario that I've seen where that happened was people never got divorced, but they separated, spouse moved to Texas, hasn't talked to them in 10 years. Doesn't know where they are.
Went on a trip and never came back.
Okay, that's a little different. But it's been a long time, you know, that people would have to get with the court. So it's a quiet title action. And at that point, the court would probably give you, like, here's what you have to do. Put a notice in the paper for 30 days. Sometimes they'll hire what's called a warning order attorney. And that's just an attorney who does their own little private investigation to find the person. And they come back after so many days and say, Your Honor, we couldn't find them. What do you want us to do? At that point, the judge will tell us what to do. Usually they'll allow the sale of the property, but they may require, you know, half the proceeds to be held with the court for a certain amount of time, or they, you know, if there was, you know, if it was like this person's property all along, but they're just so happened to be married, the court may have the master commissioner sign off on the missing spouses.
How about if it's a mail order bride that just wasn't there one day when he came home? Just asking.
Right. She's probably not on title in that situation.
What
So-
if she is?
Okay. If she is on title, then yeah, it just depends on what the judge says. But that would require a court order because you've got someone who is either an owner of the property if she's on title, or at least has that dower interest in Kentucky that would have to be conveyed away. So yeah, missing spouse is a problem, and that's unless you can find them.
Yes, can't find them.
Then you're gonna have, that's gonna take a quiet title action with the circuit court in whatever county the property is located. That's a tough one. The one that I'd seen was more of the people intended to separate, but then never went through the paperwork of actually getting divorced. You know, some people have kind of a misconstrued idea of how the legal system works. They're like, yeah, we're not together anymore, so we're not married anymore. Well, that's not how that works. I've seen people do that with bankruptcies. They're like, well, I declared bankruptcy. It's like, no, you've got to get a court action to do that. You can't just quit paying everybody. But yeah, sorry, are we, any more questions on that, Sam?
Have you read like a trust, if the daughter's mother dies, last to live in that home, she's the executrix, she has total attorney, she can sell the house.
So it depends on the terms. So you said a few things there. If the property is owned by a trust, and we'll get into that, then the trust would still own it regardless of who's passed away. So you're not dealing with an estate in that situation. You're just dealing with the trust administration.
So if she's the executrix,
If she's the trustee of that trust, then she could probably sell if the trust is entitled to the property. If the property was in the mother's name and she's the executrix of the mother's estate, then it would just depend on the terms of the will.
mother and father, actually, yeah.
That's
They
the way
both,
they're
they both.
So it just depends on what that will says. Most wills are drafted to allow the executor or executrix to sell real estate. And as long as that line is somewhere in the will saying the executrix has the power to sell real estate, they can move forward with it pretty much immediately. So that's brings me to our next question. Did the deceased have a will or leave a will? If you're dealing with a situation which is where there is no will, that's considered intestate, which means that the property is gonna descend based on Kentucky's law. Then it would go half, essentially the way it works, it's half to the spouse if they were married, and the other half to their heirs. If they weren't married, then it all goes to their heirs, and that's children first. If no children, parents. If no parents, siblings. If no siblings, then it goes like cousins, aunts, uncles, kind of grandparents down the line. Usually you can find somebody who's an heir. I've only seen once where the person left no heirs that we could find. They were only child. Yeah, at the end of the day, it would go to the estate. If you die without a will and with no heirs, it cheats. Cheats is the word to the state of Kentucky. I've never seen it actually get that far, but we did have a situation where there were no heirs and the best friend who was living with the person at the time and taking care of them filed the probate, and the court just gave it to them. They said, there's no one else who would have benefited, so that's kind of how the court handled it in that case. The last thing the court wants to do is give it to the state, just because that's a mess and it's not final. Because that's kind of just hanging out there for somebody to show up. So they would prefer, for the neighborhood, for everybody's sake, to get it to someone. Any questions on kind of what you're looking for when you find out somebody's deceased? You just kind of want to fill out the situation. Now, the answer to these questions aren't necessarily going to give you a clear roadmap. So if you're in this situation, ask those 3 questions. You know, do you have a surviving joint tenant? If not, has the estate been probated? And if not that, is there a will that you know of? And with those answers, I would reach out to a closing attorney and get some specific guidance. And I'm happy to look up the property, look up the probate estate, and let you know exactly where you stand. And there's a lot of things you can do in advance in that case if you're listing a property to kind of get those wheels turning in advance so that there's no delay at closing. If you do have to open an estate and there is no will, you know that can be a couple months essentially before you get an order to sell the property. Because when there is no will and when you have to go through probate, so the person died less than 2 years ago, any order from the court that says you can sell the property has a 30-day waiting period. So if you wait till the closing attorney gets a hold of it, gets the title search back, figures out the deceased situation, that can push you out 30 days more than you planned, which is not good, especially if rates are going up. The next steps, I kind of already said that, but once you figure out what's going on, essentially you want to just get ahead of it, let the title attorney know, and they're just going to need contact information for all the parties involved, and they'll reach out and take it from there. And again, like I said, I'm happy to do this in advance before you even get a contract on the property so that you know you're on the right track. Timeline to closing, which is kind of the big one. I know we've covered most of this already, but like I said, if there is a joint tenant with the right of survivorship, no delay, move right along as if that person never owned the property. The other benefit of that is any judgment liens that the deceased may have had against them fall away at that point. So if you've got a seller with a bunch of judgment liens and they have a joint tenant with the right of survivorship, all those judgment liens fall away if that one seller passes away. If there's a probate action, like I said, expect a couple months, maybe even 3 before you're able to sell the property. Bottom line on the estate situation is it's very specific fact dependent. So, you know, one little thing in that can change everything, so to speak. So just kind of gather up what information you have and reach out as soon as possible. That's kind of the main takeaway on estates. Anybody have an estate situation they want to go over currently? No problems. Next kind of chunk of this presentation we'll get into is trusts. Usually the way that comes up is you meet at a listing appointment and the seller's like, we may have put this in a trust a few years back. I don't know, my estate planning attorney handled all that. Or what does that even mean? At that point, the first thing you're going to want to do is get a copy of the deed to the property. And we're happy to pull that for you. You can go to the county clerk's office as well, and most of them will help you maneuver that. Some of them just say you're on your own. But most county clerk's offices, the land records are online these days, at least back 20 to 30 years. So if you reach out to us and just give us the address, we can get you the current deed probably that day. I mean, as long as they're online, it's not a problem. And at that point, you'll know who your owner is. So trusts are used for various purposes. Some people use them for estate planning. Some people use them for tax planning. That's more rare. Usually it's estate planning or privacy investing. You can also get some liability avoidance with a trust in certain situations. Usually people now are using LLCs for that part, but you see trusts for a bunch of different reasons. Sometimes trusts are created in wills as well. So you could have an estate that turns into a trust situation. The biggest question, if you realize you're dealing with a trust, is who is the current trustee? Because that trustee is going to be the one who needs to sign all your listing paperwork, sign the contract when that comes, and then it's going to have to show up to the closing. wrinkle about trustees is unless the trust specifically says that that trustee can have a POA signed for them, the default answer is they can't. Same thing with the executors on estates. You can't be a POA for somebody who's already a fiduciary, like an executrix or a trustee, or even a officer of a company. Like I'm a company, I'm out of town, I can't just assign my wife to go sign for me as a POA. There are other ways to do that, but not with a POA. So if your trustee lives out of town, you'll want to kind of get those ducks in a row, let your title company know that it's going to be a mail away at that point. Once you find out you've got the trust, you find out the trustee, and then you find out if the trustee is allowed to buy or sell real estate. That's going to be in the trust document. So a lot of people use trusts to kind of control property after they've passed away. Because the rules of that trust can sometimes not be amended by anyone. I've seen a situation where property was held by a trust, and the trust document said that for 75 years, the property could only be sold and used as a residence. Well, it was 75 acres, and the guy buying it wanted to sell about 70 lots. So he had to go, he actually got a court to remove that provision because all the parties, all the beneficiaries were on board with it, which is pretty rare. Usually a court will honor the wishes of the deceased, but in that case, it did make sense. So, any questions about trusts? Got some tips on those. Those are going to be less often. Again, generally trustees do not sign using the POA. If the trust document, if you can't find it, so the property is held by a trust as the title owner, but nobody knows where that trust document is. And sometimes one was never created. I've even seen people, sign to buy property and they're like, under trust. Well, they never drafted a trust telling people what to do. In that case, the trustee can sign what's called a certificate of trust, and essentially that just lays out the rules. And they are signing to say this is true, and that allows other people like your title company, your buyer, to rely on that. So that's kind of a good workaround. And sometimes people have the trust document, they just don't want to give it to you because it's for privacy reasons. And they don't want that to be public. And that's fine. That's why the Kentucky law allows for the certificate of trust. That way people can keep their privacy, and other people who need to deal with the property can rely on the promises. One big problem we see with trusts is that if a trust is the seller, the trust gets the seller's proceeds. People don't think about that when they put real estate in a trust. They're not thinking about when they go to sell it, which means most banks are not going to let you take a check in there that says trust under agreement dated, December 1st, 1986, and put it in John Smith's account. They're going to want a trust account for that. If that's the situation you're in, there's a few ways to handle it. First thing, it's easier if you're doing it up front, so early in the beginning. You can either have the people open a trust account. That's not too difficult. You just have to get a tax ID number for the trust and go to a bank, open the account. A lot of sellers don't want to fool with that. They just want a check in their name at the closing. The way to get around that is to go ahead and quit claim that property out of the trust into whoever wants to sell it, usually the trustee's individual name. Then when you go and sign a contract, now it's owned by the individual and they can sell it. Make sure they check with their CPA before you do that, just in case the whole purpose of the trust was tax purposes. You don't want to, for their own convenience, put them in a bad spot. But that's one way where your title company is going to issue you a check in the individual's name. Usually that's the biggest problem with trusts. People don't think it through, they haven't prepared for it, they don't have a bank account to put the proceeds when they get it. All right, now we'll go to fiduciaries in general. So a fiduciary, like a trustee or an executor or executrix, is someone who's signing on behalf of another entity or another person. POAs, the agent who shows up as the POA is a fiduciary for the principal. vice president of a company or a member of an LLC that's signing on behalf of the company, those are fiduciaries. Trustee is a fiduciary of the trust, executor is a fiduciary of the estate. What that means is you are legally bound to do what's in the best interest of the entity or person that you're signing on behalf of. And fiduciaries do a lot of real estate transactions. The biggest one we're going to talk about is power of attorney. These are typically done for the convenience. You know, somebody's out of town, lives in another state. Well, we'll just have a POA signed for them. That's great. I would much rather see a POA closing than a mail-away closing. It just gives you much more flexibility. Things change at the last minute. Maybe the walkthrough discovers some issue, and we decided we're going to do a $500 credit. That means all new closing documents get drawn up the day before. If the seller's already mailed their documents from Washington State, that's probably going to delay your closing. If you've got a POA, you change the documents, they'll give the principal a call, hey, here's what happened. Sounds good, go ahead and close it. So I prefer the POAs. I think it's smoother. If you know that someone might be out of town, go ahead and have one signed. And you can limit those. So POAs come in a few different types. You've got a general durable POA, which is kind of the overarching, it's what spouses give to each other for their own convenience that they can use over and over in any situation, practically any situation. But then there's ones you might be more familiar with real estate closings where the closing attorney will draft it just for that closing. It'll be specific to this property address and specific to this event, whether it's a refinance or a purchase, whether you're a buyer or seller, those can be set up in advance. That's what I would recommend. Now, if there is a lender involved and you're representing the buyer, you want to make sure that you check with that lender as to who can be the POA. Different loan programs limit who it can be. If you're getting a VA loan, you can't just have your buddy or your neighbor show up and sign for you. It has to be an immediate family member under VA regulations, or an attorney who is barred in that state, who has a license in that state. Sometimes they'll allow fiancés. It kind of just depends on the lender. I've run into that a lot, where the strict VA regulations say immediate family member. Most lenders will say that doesn't include a fiancé, but I have seen a few situations where they let it slide.
Yeah, I saw one of those. The lender called and he was like, "Congratulations, you're now engaged."
Yeah.
That's how this loan's gonna go through.
Yeah. So, or you can pretend to be a fiancé, apparently. But you just want to. The point is, make sure the lender's up and up with what's going on. There are other loans that they don't allow POAs at all. Typically, those aren't purchases. The one that comes to mind is a cash-out refinance. Most lenders will not let a POA sign on a cash-out refi. And you can kind of imagine why. They don't want fraud, essentially. If you're, oh, I got mom's POA, I'll just go pull 60 grand out on her house. I'll make the payments. She'll never know until I decide to stop making the payments. So lenders don't want to be in that situation. Usually cash-out refis, you got to show up for. Some POA tips. One, if a POA is durable, then you can continue to use it after a person becomes incapacitated. So durable POAs are usually set up for the elderly folks. Someone who's getting up there in age, maybe showing some signs of dementia. Their families will get a POA in place so that they can take care of their affairs should they not be able to in the future. One thing that I see get confused a lot is POAs cannot be used after the principal passes away. POA lets you do anything the person could do for themselves, but if they're deceased, they can't do anything legally for themselves anymore. So after somebody passes away, POA is no longer in effect. It goes away. POAs for real estate transactions have to be recorded. So you can't use a copy. You can't. You have to have that original document to get recorded in the land records. In the situation where you do have the elderly owner and the agent's like, I can't get another one of these because they're no longer able to sign it. They're not always going to want to turn that loose. In that situation, the best solution is have the attorney in fact, which is the agent who's going to show up and sign, go on and record that POA at the county clerk's office in advance, and then you're done. Then they don't have to let go of the original. And most county clerk's offices for POAs, for that exact reason, will let you do it the same day. You hand it to them, they'll go record it, 10 minutes later they'll give it right back to you. So that's typically the best solution if you have a client who's like, I really don't want to just let go of this. I mean, I'm sure the attorney's office will take care of it and get it back to me, but what if they don't? Or what if I need it in that 2-week period where it's being recorded? You can go ahead and have them record it already. Another thing, POAs have to be notarized. We're getting better about this in Kentucky. We have a RON statute, which is remote online notarization. And our office is set up for that as well, which allows you to get something notarized online. So kind of a take dot loop with a notary. It's pretty cool. Now, for most purchases, the lenders aren't on board with that yet. But if you've got a cash deal, you can do that all online. If you've got a POA that needs to be signed and the person's on vacation, even if they're in the Bahamas, out of the U.S., Ron Notary is recognized in that case as well. So it's a lot more convenient than having somebody go to the consulate or an embassy. A few years ago, before Ron was allowed in Kentucky, we had a lady who was in India and needed to sell a house she had in Kentucky. And she had to travel, I think it was like 8 hours by train and car to get to the U.S. Embassy to sign one piece of paper and then go back. Those days are over, thankfully. So, and again,
Charge for that,
for
the notarization.
I think most services do have a charge for that. We're set up with Stabby. I think it's about $50 for a closing. So if you had a cash deal, $50 charge. Essentially the same price of a UPS shipping label for overnight. So nothing's changed compared to what it would have been in the past as far as actually shipping the documents, as far as the price goes. But there is a fee for those. Yeah. Let's see. Yeah, I think we've covered the rest of it. Any questions on POAs? So in 2020, Kentucky redid its POA statute. You may have noticed for a few years there you had to have witnesses on a POA. That's no longer required. I included the statutory POA for Kentucky in your all's notes, or in your all's folders. So there should be another document package in the folder. That is in Kentucky law. So that language is set up in the statutes to say, here is the standard form of a durable general POA in Kentucky. So you could pull that out. If you want to do a POA with your spouse, write the names and addresses in there and off you go. If you all have someone who wants that, like I said, it's easy. You don't have to be an attorney to do it. You're not practicing law by filling out a POA for yourself. You might be considered practicing law if you're doing it for somebody else, so just hand it to them and let them fill it out to cover your bases there. But that is for everything, essentially. So that would cover, that's more what you would do if you've got a long-term relationship with somebody, not just for a real estate transaction. If somebody's wanting a specific transaction-specific POA, just let us know and we can get that to you. Again, it's something you can do in advance. And if it turns out you don't need it, great. It doesn't have to be recorded, no recording fee. But if you think, oh, so-and-so gets pulled away from work a lot, or they're a firefighter, who knows what their schedule will be kind of seller, have their spouse or somebody go ahead and sign a POA with them, have them sign a POA for somebody else. That way you're not in a tight spot at the closing. Like I said, no more witnesses. That's gone. So all POA needs is a notary and the signature of the principals, of the person who's not able to make a closing. The person signing on their behalf doesn't have to sign it. Other examples of fiduciaries. So you've got the guardian. Guardianships can be very time consuming in a real estate transaction because any sale of a property that's owned by someone who has a guardian appointed for them has to go through the court. The court has to approve that sale. Guardians get appointed when a minor receives property. Usually it's a minor who is inheriting something, because you wouldn't intentionally give a minor property. But if, you know, a parent passes away while the kid's still under 18, they can receive life insurance proceeds. That money would then need a guardian appointed to spend it, or they can receive a share of real estate, and that would require a guardian to be appointed by a court, and then you need a court order to sell that property. That court order also has a 30-day appeal period, so something you want to get a jump on if it turns out that you've got a minor owning real estate. Conservator is similar. Usually those are done when it's just the financial affairs. So could be for a minor, could also be for somebody who's, like think of the Britney Spears situation. She was able to decide what happened to her body. She could make her own decisions, but she couldn't handle her financial affairs. So she had a conservator in her situation. Curator is usually the term for someone who's handling the financial affairs when someone is disabled. So these come in primarily two forms. Usually it's a minor who used to have a guardian who then turns 18, but say they have some intellectual or physical disability that they can't make their decisions for themselves. The day they turn 18, they'll go back in front of the court, and the court will decide, okay, your parents used to take care of you. Your parents are still going to take care of you. We'll appoint them as your guardian even after you're 18. It's actually most jury trials in America are appointing curators or guardians after a kid turns 18 that has a disability. Or for the elderly. Again, if you've got someone who's unable because of an accident or just age and infirmity to take care of themselves and make their own decisions, then the court can appoint a guardian for them as well. You're still looking for that 30 days after that. So if there's a durable POA, go that route. Just let somebody sign on their behalf. But if there is no POA and the person's not able to sign on their own behalf anymore, you'd have to go through the guardianship process. Another thing that at the bottom there, the authorized signer or closing agent, these are for LLCs, companies. You know, if you've ever had a closing with Ball Homes, you might know Kay Conley. She's been their signing agent for decades, and she knows what she's doing. She's great at it, but she's a fiduciary at Ball Homes. She's a closing agent for them. You don't have to be an owner. It just has to be handled with a corporate resolution. So if you've got an LLC that owns some property, you're selling the property for the owners are going to be out of town, they can appoint really anyone they want to be, other than the buyer, to be a signer for the company. And they would just have a resolution signed by all the members of that company appointing whomever they want. It's a good point, though, about the buyer. You can't have those self-serving transactions. Same thing for a POA. If your mom's POA and you want to transfer mom's property to you, you can't sign on behalf of her giving it to you in most situations, especially not if there's a lender involved. They're not going to allow that. And most title companies would be uncomfortable with that, including us, because that's just, it's not a good look. Unless there's some certain circumstances. Like I've only allowed that with us once, and it was the parent was blind, and it was just going to be a lot of signing for them. So that we allowed the POA, the parent was still there, knew everything was going on, had no disability other than blindness, and we allowed them to do the daughter sign POA on their behalf with everybody there just to make the signing easier. But unless you've got some situation like that, you never want to be on both sides of the deal. Another thing I would recommend never being a POA for your clients. Anyone who's involved in the transaction, anyone who's receiving business from the transaction, whether it's a real estate agent, insurance agent, title company, lender, you don't want to also be involved in signing for the transaction. I see it happen. I've also seen signers sign on behalf of companies. Get a resolution and you show up and be the closing agent for the company. It works. There's no legal prohibitions. We're not going to disallow it in that case, but it's just not good practice for your case because you run the risk of the owner of the company saying, "I told you, we discussed this. I wanted 350,000, not 340. You went and signed the settlement statement and the deed for me under this lower one." I would just recommend that conflict of interest not being brought up. If you're in a tight spot and need to do it, I would just cover yourself by sending the exact documents you're going to sign to them via email ahead of time and let them reply. Everything looks good, move ahead. If there are any changes, do it again. Send it back to them. That's about as good as you can get on that kind of coverage. Because again, what you're worried about is somebody saying, "Well, I changed my mind." You didn't listen.
Question on
go
there,
ahead.
sorry. So when we take a listing for an LLC and we want to see who the authorized managers are, is that the name of the document, the corporate?
Yep.
So we just ask them to
You get a
get
company
a
or
copy of the
corporate resolution.
and that shows who the authorized managing partners are that can sign?
Mhm.
Okay.
Yep, and they can even appoint one of them. So sometimes if they don't want to draft a resolution for that transaction, they can provide you the operating agreement, which kind of describes
Okay, so
how the
that's-
entire company works, and that
Okay.
would have who's allowed to sign on that
Okay.
as well. I just recommend the corporate resolutions because they're specific to the transaction. Everybody knows what's going on. You know it's been done recently because they just sent it to you and it's dated. Because what you can run into with operating agreements is they don't. Most small like rental company, if you got mom and pop investors, they got 10 properties here or there, they are not going to keep up with that, right? They did an operating agreement back in the 80s or the 2000s when they started the company, and it's not been changed, and people have been bought out, and cousins have come in, and I would stick with the resolution, but the operating agreement would also be regulated.
Okay, so wait, I'm just confused. Okay, so the corporate resolution is something that they will have to draft then for that particular.
Right, unless they
transaction.
got one on file or got one that they've done for a prior closing that just says so and so is a signing agent for this company, like the ball home situation we were talking about, or if it's somebody who sells a lot, they're going to already have
Okay,
one on file. But it's not it's a one-page thing just saying, we're the members, we met this day, we decided this person is going to sign on behalf of the company, and they all sign. We draft them all.
So, and it's different than the operating.
Yes, the operating agreement controls all of the operations of the company, which is why it'll be between 10 and 50 pages.
So can you just get that portion, like can you just ask them to send you just the portion that,
You could, yeah, if you
shows
just
that-
wanted to know who to
Okay.
do it. You can also check the Secretary of State's website in Kentucky. You can do a business lookup, type in the name of the business, and it will tell you from their last annual report who the current members are of an LLC.
Okay.
Should at least give you an idea of who the owners are.
Right, and that way it helps too with the signature lines when you're
Right.
doing your documents.
Yes, for the listing agreement and the contract, obviously, you want to get that, especially the listing agreement. You don't want to get in a situation where two people own the company, one of them decides they want to sell it, and the other one doesn't know what's going on until you get to the closing table. That's pretty rare. Any other fiduciary questions, guys? We're about wrapped up here. Again, the main point here is just know when you're in a situation where you might have a fiduciary and know the questions to ask. And then you can reach out to me. I'm happy to take those questions, point you in the right direction. Like I said, the sooner the better. I'd rather have a conversation about it in March than the closing in June. And that makes sure you're not delayed no matter who does the closing at the end of the day. At least you're on the right track. And there is some wiggle room there, but for the most part, we'll be able to tell you what title company in general would require in your situation. Any other follow-up questions or interesting scenarios on fiduciaries, trusts, estates, POAs.
I have a question.
Yeah.
Scenario that happened to me in the past, I was representing buyers. Middle of a transaction, one of the sellers died.
Yeah.
Happens and stuff. So in that case, it was like